Welcome back to West Virginia Gun Law. I'm attorney Todd Leneve. Let's talk about Castle Doctrine. Now, most people are probably familiar with the legal concept of Castle Doctrine, which is simply a doctrine that says if you engage in a use of force to protect yourself or others within your own home, there is a certain level of immunity that may be applicable in a criminal prosecution of that case. Meaning, you may be able to escape prosecution based on the immunity provided by Castle Doctrine. Now, West Virginia doesn't have a Castle Doctrine law as such, and so we don't have an automatic immunity even if we defend ourselves within our own homes. However, we've got a civil law statute that addresses civil liability immunity in the event that someone sues you after a self-defense incident. And by the way, that's the way a lot of criminals are. They break into your home, they lose the fight, and then they, if they survive, or their family, if they don't, sues you as the homeowner for injuries or death inflicted on that invader. So under this civil law statute here in West Virginia, you do have the argument of immunity from any civil liability. And the great thing is that that statute has also been used by criminal trial courts around our state to better clarify for jurors what self-defense within the home really means. Let's take a look at West Virginia Code 55-7-22. A lawful occupant within a home or other place of residence is justified in using reasonable and proportionate force, including deadly force, against an intruder or attacker to prevent a forcible entry into the home or residence, or to terminate the intruder's or attacker's unlawful entry if the occupant reasonably apprehends that the intruder or attacker may kill or inflict serious bodily harm upon the occupant or others in the home or residence, or if the occupant reasonably believes that the intruder or attacker intends to commit a felony in the home or residence, and the occupant reasonably believes deadly force is necessary. Now that's a lot to unpack, and we'll get to that in just a moment. But first, let's take a quick look back at West Virginia's self-defense law, a topic that we've discussed a handful of times here on the channel. But our state Supreme Court has ruled that there are 5 elements to determining whether or not somebody meets the standard to be able to argue self-defense in their criminal trial. And before you can argue self-defense, you've got to establish for the trial judge's satisfaction that all of those elements are sufficiently present for the judge to be able to allow you to then move on making an argument of self-defense or legal justification for your use of force. Let's take a look at a graphic that I've put together that better illustrates this concept. As you can see, this chart shows the 5 elements and illustrates that those are innocence, imminence, reasonableness, proportionality, and sufficiency. Now, innocence means that you have no wrongdoing in creating the defensive encounter that occurred. Imminence relates to this being an immediate active threat. Reasonableness looks at subjective reasonableness, meaning in my own perception, and objective reasonableness, meaning in the perception of somebody standing in my shoes in the moment that I was forced to defend myself, and whether or not they would also agree that all of the decisions and actions were reasonable. The 4th element is proportionality, which relates to the nature of the threat presented in terms of the person-to-person relationship and the physical threat, the type of weapon or the type of attack that's being faced. And then the final point is sufficiency, which again relates to all of the other 4 substantive elements and whether or not there's enough evidence of those for the trial judge to look at and consider whether or not self-defense justification is going to be able to be argued in the case. So let's back up now and reevaluate the statute with the idea of these 5 elements in mind. And we'll see as we go through the statutory language again that the elements of self-defense are embodied in that statute other than the point of sufficiency. But all the other elements are included in the statute, and we'll take a look at those. So first off, when we're talking about innocence, again, remember we're talking about somebody who is not engaged in any wrongdoing. Well, under the statute, a lawful occupant within a home or other place of residence. Clearly what we're saying here is that you've got to be lawfully in that home and you're not engaged in illegal activity. So that satisfies innocence. You've done nothing wrong, you're just in your home. So next then we look at the statute providing the means for the homeowner, the occupant, to use force in defense of themselves or others. Is justified in using reasonable and proportionate force, including deadly force, against an intruder or attacker. Now this section, obviously, we're talking about both reasonableness and proportionality, things that come from our elements of self-defense law. So again, we see those have to be present. Even though you're in your own home, you've got to act reasonably and proportionately, which can include deadly force, per the language of the statute, if you can demonstrate through sufficiency of the evidence that deadly force was necessary. Now here's an interesting point in the statute in which it says that this level of force may be used to prevent forcible entry into the home or to terminate an intruder's or attacker's entry into the home. Now first, when we're talking about an attempted forcible entry or a forcible entry that has occurred, we're talking about an imminent situation. It's an active, ongoing, current threat. The person's trying to get into the home or they've made it into the home. So we're now saying that we've satisfied imminence as well as we look through the statutory language. Even though it doesn't specifically use the word imminence, this scenario that's being described relates to an imminent threat. It's one that's happening right now. Somebody, again, is breaking in or has broken in. So where this becomes interesting is that this law makes it clear that you don't have to wait for the intrusion to happen. You can actually defend yourself while the person is outside trying to get in to prevent a forcible entry into the home. Okay, so what that means is the old adage, if you shoot them outside, you better drag them inside, doesn't apply anymore under our law. The law says that you may prevent that entry, and that may be that you prevent it through shooting somebody through a window or through a doorway. And we have cases in this state that support that type of action based on trials that have occurred and acquittals that have taken place when people have done just that. So you don't have to wait till they get inside, and obviously shooting someone outside and dragging them inside doesn't really work with today's modern forensics. Plus it could be considered tampering with evidence, which is a whole new boatload of problems that you don't want to get into. But then the statute goes on to say also that you may use that level of force to terminate an intruder's or attacker's unlawful entry into the home or residence. And so what that means is, again, maybe they've succeeded in getting in before you're able to respond. But our law allows you to try to prevent the intrusion in the first place and to stop it in the second place if it has already occurred. Now the final part of the first paragraph, it indicates that you may use that level of force that's necessary to prevent or to terminate the attack, but that you also may use that level of force if the occupant of the home reasonably believes that the intruder or attacker intends to commit a felony in the home. And here's the reality. If somebody is coming into your home without an invitation and they're using force to do so, they probably are there to do you harm. Now, when we talk about a felony, we're not talking about somebody sneaking into your house, stealing your nice big TV and making their way out, or your jewelry, or whatever the case may be. That may be a felony based on the amount that's involved. but we're talking about felonies that involve violence. So again, a physical attack, an attempted murder, a kidnapping, a sexual assault of some sort, any of those kinds of things are most likely felonies that would result in death or serious bodily harm to the individual who's occupying that home. And so if somebody is breaking into your home, it's not a recognized legal presumption, but it's probably a fair presumption that they're there to do harm, that they're there to commit some evil act against you or someone in your family inside that home. And to be fair, most law enforcement probably will also see it that way. But the problem remains that West Virginia doesn't currently recognize an immunity for acting against people who've broken into your home. You can certainly argue self-defense, and you certainly have civil immunity, but there is not a legal immunity that prevents prosecution just because you're inside your home. You've got to have all those elements of self-defense present. But again, the reality, folks, is that if somebody's breaking into your home forcibly, most people who are investigating this, most people who have to evaluate it, such as a prosecutor or even potentially a grand jury or a trial jury, are likely to see this for what it was. This was a reasonable act in which an innocent person defended themselves against an intruder into their home who was bent on creating some kind of harm. But again, we don't get where we are in life by making presumptions about anything, so we have to be prepared to back up our actions and our decisions with as many facts as we possibly can. Now, this is an area of law that certainly I think West Virginians could benefit from having a modification to our statutes that allow this type of Castle Doctrine argument to be put into law to provide some level of immunity like it does in other states. And we would benefit from that in trying to defend ourselves, defend our actions and our choices in using force against somebody who'd broken into our homes. But until that law changes, we simply have to be sure that we can meet the standards of self-defense, and we hope that we deal with reasonable law enforcement and prosecutors who would be willing to look at a case like that and recognize it for what it is. I appreciate you guys spending a little bit of time here with me today. Please take a minute, drop a comment or your thoughts down in the comments section below. Hit the like button on this. If you wouldn't mind subscribing, I'd sure love to have you as part of the channel community here. Pass this video along to anybody else who you think may benefit from it. And again, thanks for spending the time with me. Until the next video, take care and stay safe.